This video is about Ouster of Board of Directors. Board of Directors are elected group of individuals that represents shareholders. The board is a governing body that typically meets at regular intervals to set policies for corporate management and oversight. Every public company must have a board of directors. Some private and non-profit organizations also have a board of directors. We can say that board of directors are the group of people who jointly supervise the activities of an organization. Their powers, duties and responsibilities are determined by government regulations, the organization's own constitution and bylaws. The board is responsible for protecting shareholders' interest, establishing policies for management, oversight of the organization and making decisions about important issues that are faced by the company. Removal of board of directors. Disputes between directors can be difficult to manage, particularly where the director is in question is a shareholder. Business work because of the relationship between individuals, and when these relationships break down, problems can arise that affect the business, its reputation and also reputation of the individuals. There are no easy solutions, but the Companies Act does provide for removal of directors by shareholders, although this must be seen as last resort, particularly as the process can give rise to animosity, reputational damage and legal costs. Board of directors are the representatives of shareholders. They should protect the interest of the shareholders, but we cannot say that the opinions of these board of directors are always in harmony with the shareholders. There could be differences in opinions which can cause disputes. There are certain situations where the company prefers to remove the board of directors. They are as follows. 3 cases of removal of board of directors where the director himself gives his resignation. To remove a director suo motu by the board in case the director does not attend 3 board meetings in a row. These are the 3 cases where board of directors can be removed by the company. Let's see the procedure that should be followed under each case. First one, where the director himself gives his resignation. Here the director is not willing to continue being as a part of board of directors of the company and gives resignation to his positions. The concerned director submit his resignation to the board. In this case, the following steps will be taken to remove his name from the register of directors. The company will hold a board meeting by giving 7 days of clear notice. Here clear notice means 21 days notice excluding the day on which the notice was sent and received. When the board meets, they will discuss amongst themselves and decide whether to accept the resignation or not. Here the board of directors, other board of directors have the right to reject the resignation and convince the concerned director to continue being as a part of board of directors of the company. They can also accept the resignation. Once the board accepts the resignation of the director, they will pass a board resolution accepting the resignation. Here, the board resolution is a formal legal record of decisions made by the board of directors during the board meetings. If they accept the resignation, they have to write it down in the form of resolution. After the passing of resolution, Form DIR 11 has to be filed by the outgoing director along with the board resolution, proof of delivery of the resignation letter and copy of resignation letter. Here Form DIR 11 gives detailed reason for resignation. It is prescribed by Companies Act 2013. This form saves the director from any future action against him. While the filing of DIR 11 is the responsibility of the director. Form DIR 12 is the responsibility of the company, which has to be filed with the registrar of the companies along with the resignation letter and the board resolution. Form DIR 12 is a proof for the company which contains the notice and evidences of resignation. After filing all the forms, the name of the director will be removed from the master data of the companies on the Ministry of Corporate Affairs websites. Here, Ministry of Corporate Affairs is primarily concerned with administration of Companies Act 2013, 1956 and other acts, rules and regulations, mainly for controlling the functioning of corporate sector in accordance with the law. They maintain data containing details of the directors. After filing the forms, the name of the director gets removed from this master data maintained by the Ministry of Corporate Affairs. It is all about the first situation. Second one, to remove a director suo motu by the board. Here suo motu in general means on its own motion. Here in this case, the company is removing the director on its own initiative. A company has the authority to remove the directors by passing an ordinary resolution, given the director was not appointed by the central government or the tribunal. A board meeting will be called by giving 7 days notice to all the directors. A special notice will go to the directors informing them about the removal of the director. Any decisions regarding the company will be taken in board meetings. Therefore, 21 days notice will be given to the board of directors. Since the company is removing one of the directors, a special notice will be given. On the day of board meetings, a resolution for the holding of an extraordinary general meeting will be passed along with the resolution for removal of the director subject to the approval of shareholders. In the first case, decision is taken in the board meeting itself, but here a general meeting is needed. A general meeting will be held by giving 21 days clear notice. In the meeting, the members will be asked to vote on the matter. If the majority is in favor of the decision, the resolution will be passed. Here, the opinions of the director is very important. Decision is taken on the basis of majority votes. Before the passing of resolution, an opportunity of being heard will be given to the director. The concerned director may have his own explanation for his actions. Chance will be given to him to be heard. After the passing of resolution, the same procedure will be followed and the form DIR 11 and DIR 12 will be filed along with the same attachment of the board resolution, ordinary resolution. Form DIR 11 and DIR 12 are essentials for companies. The one is filed by the director and the other one is filed by the company. After filing the forms, the name of the director will be struck off from the Ministry of Corporate Affairs website. It is similar to the last situation. Third one, in case of directors does not attend 3 board meetings in a row. Attending the meetings is very essential because all the decisions are taken in the board meetings itself. If a director fails to attend 3 meetings in a row, the company can remove him from his position. As per Section 167 of the Companies Act 2013, if a director does not attend a board meeting for 12 months, starting from the day on which he was absent at the first board meeting, even after giving due notice for all the meetings, it will be deemed that he has vacated the office and Form DIR 12 will be filed on his name and his name will be removed from the Ministry of Corporate Affairs. Here directly the Form DIR 12 will be filed, because filing the form DIR 11 is the duty of the removed director, not the company. It is all about the ouster of directors in three situations. First one, where the director himself gives resignation. Second one, the company itself removing the director. And the third one is the director not attending three meetings in a row and getting removed by the company. It is all about ouster of board of directors or removal of board of directors. Thank you.